I know this is a panel after lunch, and as usual, I have to say that it's so difficult to, have a session after lunch. But I guess, and that too on tax. And I'm not a tax lawyer, just as a disclaimer. So on both of my side, they are the tax experts. We were supposed to have from a person from industry, Samir, as a part of our panel to moderate, but unfortunately he could not make it. So I've taken upon myself to moderate this session. So before we get directly jump into tax, let's see what has happened over a period of time, last few years. The conversation, just to clarify, is on the real money gaming in India. And when we say real money gaming, we are talking about games of skill. We will also discuss on games of chance, how the law, on the GST, how they have equated along, with the game of skill, and all of those nuances. We'll definitely talk about it. But insofar as regulatory landscape is concerned, there have been developments on the positive side. We saw the Ministry of IT, that is Information Technology, being given a charge to be a regulator for the real money gaming. The law doesn't specifically say that it is for skill or chance or otherwise, but they of course talk about legal gaming, which in the Indian context is known to be skill gaming. Of course, we have state-wise nuances which we are not going to discuss on this. There are other panels, I'm sure, who will deal with that. But essentially, the MeitY came out with regulations to sort of have a co-regulatory model with the, and why am I discussing that is because just to show that the central government took upon itself to, sort of give that kind of safe harbor to say that, okay, if you're doing these things in this manner, you can conduct your business, right? That was a message that we saw coming from the ministry. And any industry that, that needs to flourish, not only does a regulatory policy, sort of needs support from that, but it equally needs support on the tax policy, because if the tax policy falters, the industry is likely to suffer, and we will discuss today, what are those elements that needs some correction even now. So we saw in last couple of years changes both in the direct taxes, which is your tax deduction at source, and we saw also changes in the GST, the goods and service tax. So when we talk about TDS, we always had a provision under the Income Tax Act, and though we are lawyers here, we are not going to talk sections and all of that. We are going to discuss principles. So in the Income Tax Act, we did have a provision on the tax deduction at source for winnings from games, right? There was a certain regime, but the regime has changed. So I'm going to ask Asish to very briefly talk about how the regime changed, the positives of that for the online real money gaming players, and we would invite Rajat on his thoughts as to is there something, or rather both of you can sort of express as to, do you believe something more needs to be done? Is there any further clarity required on that front, or we are good?
Thanks. So as she explained, as the sector has been evolving. Like 2 years back, the question was asked, how is the tax certainty in the sector? There were multiple questions or doubts. But the way the law has been evolved, both under direct tax and the GST, it's a good for the sector. For the specific question on the direct tax, the companies were facing the challenges when various formats were there. And the earlier regime was for a situation where in a physical environment, games were conducted. A player walks into the casino, a player walks into the gaming room with a prize and wins the money. Or a player plays something like Kaun Banega Crorepati, wins the prize. So there is a definite start and end to the game. So time of deduction of TDS for winnings were easier. When the regime changed with the 5G and adoption, gaming got a boom in the COVID and adoption of 5G as a 4G and 5G as a technology. So in that period, when the number of users, more players have come up with a various innovative format. Poker, rummy, fantasy sports, fantasy was a totally new concept in India. Poker, etc., which was a physical format, were conducted in online. So when to deduct TDS, this thing was a confusion. Every game is a game or not, every time. And in nuances game, you deposit 1,000 rupees. With 1,000 rupees, you can play 10 times the same game. Each time when I win, so there's uncertainties when to deduct, or at the time withdrawal, less than 10,000. That's the only time I need to withdraw. This uncertainty was settled in Finance Act last year to say that new class has been defined for online gaming, recognition has been given, we will be treated separately. They said that you deposit the money minus the winning, that is the net amount. That is the only amount on which TDS need to be deducted. It has brought certainty towards the players as well as for the pays. Earlier regime, always there used to be confusion. Players used to question in the social media that whether it is correct or not. So from that perspective, yes, it's a good thing. Yes, there are some teething, this thing on the closing balance, etc. Are small niggles to be wriggled out all the time. As such, direct tax reform has been a positive impact on certainty aspect.
Thanks for that background. And that question was always, that 10,000. How do you calculate 10,000 throughout the year? So different platforms were taking probably different approaches, basis the legal opinions mostly. But because there were different approaches possible, it always created confusion, as to, how it should be addressed. And now I think, as you rightly put, that confusion has been put to rest, and which is a good thing for the players also. But Rajat, do you believe that there is some further clarity or some further positive change required in this regime?
Well, I feel from a GST standpoint, on the TDS part, I think Asish has very well put it, that the changes which has been introduced in the Finance Act, they are sort of, they bring a certain level of certainty. However, yes, as is with tax law, I don't think you can ever get certainty on anything. So, be that as it may, it's going to evolve over a period of time. It's of course a very new sector to begin with in India, and I feel that teething issues, of course, will always remain. But having said so, at least the government is thinking about it. The government wants to sort of regulate it positively, and remove whatever ambiguities are there.
Right. So even when we saw, they came out with the FAQ, right? I mean, because there was in the Indian context, right? What happens really is there are very micro transactions. And I think they gave that in the FAQ, though it's not a very happy place to give the clarification, but that 100 rupee clarification that came in. I think that was a good thing that, okay, if it's more than 100 only, then you deduct, etc. So some of those things, if they're actually in the act or the rules, that gives more certainty, because FAQ, whether it is binding on the department or not, that question always arises. But I think some of the things, on the tax part, we also understand that certain players may have received notices, what we have understood, right, that they have not paid tax. So of course the platforms will deduct tax, they will do their filings, but the players themselves also need to do their filings, without which of course they will receive a notice. So any thoughts on, because this question did come up yesterday, as to what should be the platform responsibility on this TDS part, so that once we discuss that, then we can move to the GST part. But when the players receive notices, is there any expectation from the platform side?
So this is an investigation of data sharing. One department sharing the data with another department. Data collected by GST authority has been shared to income tax to say winning score the player is X, TDS deducted is Y. Did he report in his individual income tax return same amount or not? So as a platform, who are person liable to deduct TDS, once it is deducted and paid, we don't have any other responsibility. The person paying the income tax, it is his responsibility to include this income as part of his return. Even as a player, highest rate TDS is deducted. Once highest rate TDS has been deducted, no other income will be subject to taxation. Like 30% TDS is deducted, so more or less the bracket in which it falls will be within the range, so there will be no extra tax outlay except for the return year, file the return for short filing.
Thanks for that. I think essentially, I believe it would be also good for the platforms, and sort of it may, like, whichever platforms, whether it is like, and we will need to see whether we'll come to you both of you on the once we deal with RMG, even the social gaming as well. But I think the best thing in these contests is always for the platforms to create player awareness, because sometimes the players could be across different strata of the society. They may not be aware of their obligations to pay taxes. They may not be, or rather they may not be coming in the tax bracket in the first place, right? Regular tax bracket. But because now their income has been taxed, they'll have to file the tax return, right? So I think some of these obligations, if the platforms can, in their terms and conditions or through their advertisements or otherwise, can make the players aware, I guess that will at least help the players also to comply with their tax obligations. So let's move to the more controversial part, which is the goods and services tax. Many of you must have been reading in the papers that so and so company got GST notice for 12,000 crores, 16,000 crores. The numbers are huge. So what exactly, Rajat, coming to you, what exactly happened? Why are the platforms receiving these notices? If you can just explain the past, then and then we'll come to the present, because as we said, the law has changed last year when it comes to GST as well. So maybe you can briefly discuss that. But what are these notices for? I think audience may want to know that as well.
Sure. So essentially, what has happened over the years is that there are various kind of online gaming companies. Some are sort of based purely on skill. Some are maybe not so much on skill, but more on chance. And there are other kind of gaming or social gaming companies as well. Now, what happens is that the controversy was always on whether a particular game or a particular event is a game of skill or a game of chance. Why this controversy was there is because initially, when all this online business was not there used to be certain games like horse racing or rummy, which were played at a physical level. Most of the state governments in India prohibited any kind of gambling, horse racing, etc. So therefore, there was always a dispute whether an activity actually falls within the ambit of gambling or not. And that's when the dispute started, right from 1950s, where a dispute arose whether a horse racing is a game of skill or a game of chance. A rummy is a game of skill or a game of chance. And the matters went before the courts, before the High Court, Supreme Courts, and there was sort of a clear line of decisions passed by the Supreme Court right from 1956 till date, which clarified that at least rummy, out of everything, is a game of skill. Now thereafter, when the online gaming industry was booming, fantasy sports and other kind of gaming companies were coming up, the question arose whether when you play a fantasy sport, is it a game of skill or a game of chance? Why that dispute? Simply because if it's a game of chance, then you are taxed at a higher rate under GST, which is 28%, and also your value on which you're taxed is the entire value of your bet, the face value of your bet. On the other hand, if you qualify as a game of skill, then you are taxed at a lower rate, which is 18%, and you're only taxed at the GGR, which is your gross gaming revenue. So there was a huge difference between the two different kind of platforms. Now, because obviously the taxman always wants to collect as much revenue as possible, they looked at certain games. They started with Dream 11, then they went on to other platforms, mainly fantasy sports. And they said that, look, this is not game of skill. This is a game of chance. How do you know how a player is going to perform on a particular day? They litigated. Eventually, the High Court held that Dream 11 is a game of skill, not a game of chance. so on and so forth. Then came Rummy. Now, online Rummy is very different than offline Rummy. There's a way of playing online Rummy. Every platform has certain set of rules. When you play Rummy offline, then it's very different. When you play Rummy online, it's very different. Department said that online Rummy is a game of chance. So therefore, you pay GST or 28% on the entire face value of the bet. Again, the litigation is going on, currently pending before the Supreme Court. You must have heard about Gamescraft and All India Gaming Federation. They are before the Supreme Court on this very exact issue, and so is our man Asish over here representing some of the companies before the Supreme Court on the same issue. Now the problem is that because there is this sort of new dispute which has arisen, whether a particular activity is a game of skill or a game of chance, the entire tax regime, therefore, is dependent upon the outcome of this particular question of fact. What has happened is, in October 2023, the government did an amendment and bought all online money gaming platforms at par with, gambling platforms. So they said that nothing doing, from now on, 28% on the face value, whether you are a game of skill, game of chance, whatever. But that was from October 2023. But the taxman is not happy with that also, so they said, oh, sorry, we want it from 2018. And they said, retrospectively, we will say that you are a game of chance, and therefore you have to pay 28% on the entire face value. What it has effectively done is, or it has the potential to do, is that it will sort of, it will kill the business. Because the kind of demands that we hear, as a gaming company, your revenue is only on the margin that you make, your commission which you take for the sort of for the platform. But what the taxman is asking the gaming companies to do is pay 28% on the entire bets which have been placed over the last 5 or 6 years on their platform. Now that money is not even with them. That money doesn't belong to them. There is no way that a platform whose turnover is 1,000, 2,000 crores can afford to pay 16,000, 20,000 crores in tax. They will go out of business. It's as simple as that. And that is where right now, I think from a policy standpoint, a lot of representations have been filed, advocacy is happening. We'll see, because that was something which is always, when the amendment came in October, it was always said that it will be reviewed after 6 months. So hopefully 6 months is going to get over now, and we can expect something to come out of it.
So thanks for that background, Rajat. And since you are before the Supreme Court, and I think there are two things, right? One, for the audience purpose, let's clarify, as you rightly said, that from October 23, that's a future regime. We will deal with that in a bit, but just on the past regime, and the reason it becomes a policy and a legal issue both, because if the government persists, to sort of with the demand, right? We understand the industry will not be able to survive if they really are able to sort of, have their way. So it is one thing before the Supreme Court. If Supreme Court, of course, holds in the gaming company's favor, nothing like it. But even if the Supreme Court holds against, because of the existing law interpretation or otherwise, do you think the government can still create some amnesty scheme, because there was a particular law, you were interpreting in a particular way, where the entire industry for all these years was interpreting in a different way, you had assessments already carried out, where no such issue was raised, and suddenly, one fine day you start issuing notices. I know it's not a question, but I'm just putting some points to you for you to, sort of reflect on.
When India is looked as an investment destination, always foreign investors ask a question, whether the tax policy as today, how long it is going to stand. Like when SEZ came, the law was that tax holiday will be there. Within 10 years, we changed the law. Vodafone, we changed, Supreme Court decided in favor of Vodafone, they changed the law to tax it. When the new regime, 2014, the government came, the first budget, late Finance Minister Jaitley announced that tax certainty and retrospective will be not the policy of this regime. But when you look at the gaming, that's exactly what the litigation, before the Supreme Court, government is leading. what happened was that there is a specific, in the law, there is a specific exclusion for action claim in relation to game of skill, as explained by Rajat. Game of skill was not taxable. Only the revenue earned at 18% was taxed. They amended the definition to make it. So when there's an amendment expanding the scope, no way the expansion can be held retrospective. Multiple Supreme Court has held when a new levy is introduced, expanding the scope of the existing levy, it cannot be retrospective. But in the Supreme Court, government is arguing that expansion is just a clarification. Irrespective of the amendment, prior to October, the existing provision was good enough to cover. But entire industry was following another practice. Department is canvassing another interpretation. In India, Supreme Court is the final. Whether right or wrong, they being the last authority, that decision is binding. We have seen in the AGR case, Telecom Ministry, wrong footing, they fought the matter in the Supreme Court, they won. But government was forced to fund the telecom companies to pay back the AGR. Government did not have any leeway to get back. The CJ, the former CJ had said, this is my order, you cannot amend the law or give a leeway. So amnesty scheme coming on this issue after Supreme Court deciding core gaming will be difficult. Yes, in the tax, year on year we see amnesty schemes coming. A general amnesty scheme can come. But problem is that an amnesty scheme itself cannot take care. The revenue of the gaming company was 10 rupees. The tax demand on the company is more than 5 times the revenue they earn. In the Gamescraft case, the revenue of the Gamescraft was 4,000 crore. Tax demand was 20,000 crore. So when the 20,000 crore, which is amnesty scheme, they say 25%, still they don't have the money to pay. So even amnesty scheme will be difficult. Better policy will be something similar to 11C. They say that this was the trade practice. We recognize as this basis. GST Council in multiple matters, they said that someone paid restaurant ice cream parlor, whether it should be taxed as 5% or 80%. They said someone paid 5, someone paid 18. Fine, we put a full stop. Something similar to that at the council level should be done than waiting for Supreme Court. Supreme Court comes in favor, no problem for the industry. Supreme Court goes against the industry, then becomes a difficult for the existing players.
Right. So I think it may be a better idea that because Supreme Court, sort of all of us know that it will take its own due course by the time the matter is heard and ultimately decided. So at least in the meantime, some of these sort of schemes could be considered, as you rightly said, through a council or otherwise, right? The other thing is, of course, sometimes the tax authorities may take a view that, okay, for the gaming law, you may have a skill versus chance approach, right? But tax law doesn't recognize that. I will tax the way I want, right? When it becomes a policy decision that to tax everything together, I think that is where the courts, may or may not intervene. The real issue today is the way the entire industry interpreted the law, including all of us sitting here, interpreted the existing law then, right? That is where the problem is. Now, on this point, let's fast forward now and explain as to what is the current regime now and what are the issues with that regime which was introduced from October. So, Rajat, do you want to deal with that part as to, I know you briefly touched upon it, but let's just sort of explain what is the current regime and the problem with that regime, according to you.
So, okay, one thing is for sure that the current regime is much more clearer in terms of it doesn't distinguish between game of skill or game of chance. So they've taken that equation out of the picture completely, which is a good thing. Because see, again, game of skill, game of chance can be a very fact-based question. And it's, it may not be possible every time to put something in a very sort of a straitjacket, formula. So that is good. They've said 28%, that's also fine. They said on the full face value, that's also fine. The moot point is that at least we have some clarity. And nobody is shying away from paying tax. Let me be very clear. Whatever tax is applicable is applicable. Yes, at the end of it, gaming companies, most of them are sort of absorbing that tax cost as of now. What I hear is that while the top line is not getting affected, but yes, the bottom line, the EBITDA has taken a huge hit because the tax is now being absorbed. So obviously the EBITDA is going to take away a huge hit for gaming companies. However, I think some of the points which still need to be clarified and which are sort of litigative is, on the promo schemes or on the bonus chips. Sometimes a lot of gaming companies give bonus chips or which are, let's say you win something and you get an additional 10 chips to play with. Now those chips, you may or may not be able to withdraw them ever. Maybe you are only able to play with them and do nothing with them. The language of the provision which says that, whatever amount is deposited with the platform is also subject to GST. Now deposited can also be security deposit. They also use the word whether in money or in any other form, including VDAs, virtual digital assets. Again, very nascent stage, we don't even know what we are looking at. It can cover NFTs, it can cover cryptos, it can cover anything under the sun. So these things, of course, as and when we progress in this in this gaming world, these things will get clearer as we speak, but not before litigations happen. So that is forgiven.
Just to add to what Rajat mentioned, I will say the new GST regime, what was introduced is the innovative jugaad by the government of India. This kind of scheme is nowhere there anywhere in the world. Across the world, what is taxed is the net revenue or GGR of the company. Or if it is a GGR taxation, they charge 15 to 20% on GGR. Or if there's turnover taxation, every stake, they will tax 5%. Here in India, like France, UK, they moved away from turnover to GGR. International trend is moving away from GGR to turnover to GGR. But in India, what they've done, to give an example, me, Gowree and Rajat are playing 10 rupees, 10 rupees, 10 rupees, 30 rupees a game. Company is taking 3 rupees as their platform fee. GST in the earlier regime used to be paid on 3 rupees. Remaining 9 rupees was 27 rupees was not taxable. 3 rupees, 18% paid, 27 rupees taxable. Government tax on ended 30 rupees, government wanted 28%. The old regime, the litigation happening. New regime, government said that you play unlimited times. I don't want on 30. One time when you deposit, only that time I want the tax. It's not the extreme, but not this thing. It's an innovative way of taxation. It's other developing countries are looking at our method, how to take it forward for their taxation.
Thanks for that. I think one important point you mentioned, which I want to underscore, is in the prior regime, right? Whether somebody's skill versus chance, the question was who will determine that, right? And that's where when the Métis rules came in, which I explained before, that could have given certainty because that, whichever games were registered permissible games, right? Those probably could have got that, benefit to say, okay, these are skill because they are registered games. Let's not even go skill versus chance, registered games versus unregistered games. But unfortunately, that regime is also currently in a fix. We will see, maybe in a few months time whether that comes up. But so at least the new regime is sorting that out that, okay, I'm not going to make any distinction. In a way, that gives certainty. The point that you mentioned, Ashish, that ultimately investors want certainty. So that certainty came in, right? But still, from a taxation perspective, as you said, it's a huge burden. What we understand that the GST correction may have gone 6 times than the last year, right? That's what we are told. But again, this is because probably the bonus schemes and etc. that you mentioned. And if you really see, the same, it's a tax regime only, but the indirect versus direct taxes, the TDS which we discussed before, there I think it is more business friendly in the sense that they have given clarity how the bonuses have to be treated, right? Whether they are withdrawable, non-withdrawable. So they have actually tried to understand the way the businesses work and taken that into account while framing the direct tax regime. Whereas for the indirect tax regime, for the GST, I don't think they have taken the business realities into account. And also, and the point that I mentioned right up front, that any tax policy also needs to take into account whether what is the general policy of the government. If the general policy of the government that, this is a vice industry, don't, let's not promote it. So, for alcohol and others, they keep, higher tax. But when you say that, okay, this is the industry, because there were statements made, make in India, gaming, is a part of that initiative, etc., etc. So when the government on the one hand is sort of supporting the industry, and on the other hand having a negative tax policy, I think that is where the contradiction is seen, right? So from a business friendliness, do you have any points on the GST front?
So, as she pointed out, yes, that this government, our Prime Minister has put a lot of focus on gaming. They say want to make games in India for globe. Not only for India, make globe. That's the initiative, a lot of push. There has been special task force, there has been special commission, committee, incentives, special fund, etc. has been there. Now, but coming to this tax policy, both GST and TDS, GST, yes, FAQ, etc. has been issued for TDS, not for GST. The question is, need to be asked, whether the tax policy, is it fair and equitable? In other words, whether it is neutral, whether whichever location I do the business, whether it is certain, whether it is simple and effective. Yes, from the perspective of certain simplicity, it might be scoring high. But whether how much neutral on the business is a question we will see over the time. Today companies might be absorbing the tax. But once the tax is removed, whether the players are going to grey market, offline, or the foreign companies are going to take the risk. Yes, FAWA restrictions are there, GST say foreign companies offering game need to register, etc. But how it's going to evolve is going to determine the success of this policy, whether it is, does it correct? Like UK, when they moved away the taxation from gross to GGR, they see companies moving into UK in 1 year time. There is a House of Lords committee report where they have pointed out. So in India, immediate effect might not be there. Over the period, will the players, today 500 million, 600 million players are active players in the various platforms. Whether those players are they going to move or they are going to become dormant? That are the impact business is going to see over the.
Absolutely, and especially when the tax notices are received by the players, will that sort of take them away from the platforms or not? But I think one important thing, maybe we have last few minutes left. But let's do like a crystal ball gazing, because if you remember that, some of you may remember reading this in the newspapers, when the government introduced this new regime in October 23, they said that we will wait and watch for 6 months. Now the 6 months are falling right, like as we sort of are talking, I think it's getting over. So, and the GST Council, some of you may be aware that GST Council is, sort of constituted under the GST law to look at various aspects of taxation. They are the ones who supported this 28%, or they were the ones who proposed this 28% on the deposits, etc., right? But at the same time, the government said we will revisit after 6 months. So when the GST Council, as and when it is revisiting, what is your wish list, on the GST front?
So I think also before that, I think one thing which is very interesting in this entire thing is that there's only been once, I think, ever that there has not been there has not been a unanimous decision taken in the GST Council, and that was on taxation of online gaming. So even the various state governments, I think some of them clearly are not in favor of imposing such a high rate of taxation. I think, going to your question, Gowree, as to what is my wish list, honestly, I think the wish list is that you please impose a tax. Nobody is saying don't tax, but be fair, be equitable, as Asish said. Let the rate and the value of tax have the nexus with the service which is being provided. Don't be unreasonable, because at the end of it, you'll have to first think in your own, in your own head as to where do you want this industry to go. Do you want this industry to thrive? Do you want India to become a hub for this industry, where companies come, set up, provide services not only within the country but outside the country? Do you see that kind of potential in terms of revenue generation in the long run? The answer lies in all these questions. They'll have to sit and think about it. For me, I think the wish list is very simple. For the past period, obviously, there has to be very clear instructions that go by what the custom of the trade was, so the trade practice, common trade practice was. Even if there's something is falling in a grey area, let it be, just so that we achieve a quietus to this entire episode. It's impractical to ask a company to pay 16, 15, 20,000 crores when they don't even earn 1/10 of that. Going forward, be reasonable. This sector has immense potential for revenue generation in the long run. You have to think from the long-term perspective, not just always think about collecting revenue from taxation. And yes, I think very simply put, these are the two things which should be there, which is my wish list as far as this council meeting is concerned.
Thanks, Rajat. I think one important aspect that you mentioned, which I'll just touch upon, is you mentioned that the players may go to the foreign website. So just to clarify for the audience, the GST law also requires the foreign companies who are offering the gaming services in the country to register with the GST authorities and pay tax. And some of them may also have received GST notices, for all you know. I think some of them have received GST notices as well. So we'll need to wait and watch what happens on that front as well. I think, on the Supreme Court, I think you have already explained what is going on. But in the GST Council, again, your wish list, other than what Rajat has mentioned?
Tax certainty, litigation, both aspects is discussed. One thing I feel, this thing, yes, tax, past issues are there. Like enabling the law for making Indian companies go global. The Indian gaming companies go global, there is some tweaking is required, both in the direct tax and GST aspect. That is something which government, like so much focus is put on the sector. Like yes, allied laws in relation to payment gateway, FEMA, etc. need to change. But from taxation perspective also, export of service from India for a gaming company should be enabled.
Yeah, thanks. I think that's another interesting discussion on FEMA. I hope some other sessions also take it up. But I think thanks both of you. I think we are before time, but if at all there is an audience question, we do have 2 minutes left. If there is any audience question, we are happy to take it. Otherwise, I would request IMI to sort of take these points and the suggestions that have been made by the panel members into account and make a representation to the government if we can. All of us professionals should come together and make these representation. I'm sure all of us have made representation, but no harm in making one more.
Thanks to Gowree for stepping in the last minute to moderate the discussion.